There's two types of trust administrations. There's a trust administration at the second death, and then trust administration at the first death, which we call it a partial administration, because you're basically setting it up to protect the surviving spouse and also protect the future beneficiaries as well. And if you don't do it, I am certain everyone has heard, oh, I was the child of my mom, my dad. They were in a second marriage. And then when they passed, everything went to the surviving spouse, and his or her kids took everything. We got nothing. So there's ways to prevent that. And you want to do that preventively prior to becoming incapacitated or passing. So the process of the first death, right? You take a look, was your trust divided into two buckets? Maybe it's the survivors bucket and the bypass bucket, or the decedents bucket. There's various different names that can occur for this: bypass, the marital, and then there's the survivors as well, depending on the complexities of the trust and also depending on how much assets were left. So at the death of one, basically, in a very simplistic manner, you want to separate it and put it into two buckets. One is irrevocable, one is revocable. The one that is irrevocable is being preserved for the benefit of the future beneficiaries, but it also supports the surviving spouse as long as they are alive. And so there's a process to do this where you want to collect all the assets, divide them up, make sure you can take advantage of any estate tax issue. And then, of course, the protection for the surviving spouse is key as well. You have to really allocate which assets go into which bucket so that you get a double step up in basis or a step up in basis at the second death. So the first steps, you want to locate the documents. What do the documents say? You want to look and see, were they funded properly? Were the bank accounts inside the trust or the savings accounts, or was it life insurance named as the trust as the beneficiary? What about homes? What about rental properties? What's going on and where do the assets sit? And we have a situation right now where not all the assets were fully funded into the trust, and the decedent died, and now spouse is having to collect those assets that were her sole and separate property of the decedent. They were not named properly with beneficiaries. And so, yes, we have to open up probate. Or can we do a 850 petition, which is something that we're saying, look, the decedent forgot to put this property into their trust and we're going to court. But again, you're going to the probate court for this issue to see if they will approve it. And not all trusts are the same. And so some trusts don't even allow you to ask for court permission to move the assets into the trust. So when somebody passes, you definitely want to collect all the documents. You want to collect all the assets. And then we always say, please notify us so that we can help you through the process. Because as a trustee or an executor, you owe a fiduciary duty to all the beneficiaries, right? The future beneficiaries. And so there's certain notices that have to be given out. So we give these notices out to make sure that the trustee will not have any liability later on down the road. So when you're reviewing the documents, you want to make sure and understand what you have to do. And do you have to open up probate, or can you bypass the probate process? When somebody passes, you do have to lodge the will within 45 days of the passing of the decedent. So you want to make sure and get that done as well. So when you're reviewing it, there should be a schedule of assets, and you want to see who the beneficiary is. If it's just a partial administration, usually the beneficiary is the surviving spouse. But many times, if there's a blended family, there's assets that will be distributed to the decedents as well. And so sometimes there's specific distributions. If there are credit cards in the deceased name, you want to make sure and close those credit cards out because of fraud. You definitely want to get an appraisal of joint property and separate property so that you get that step up in basis. So beneficiaries often reach out. The trustee, the executor, they won't send me a copy of the trust or the will. What kind of rights do I have? And the trustee does owe a duty to the beneficiaries, and they should send out notices regarding the administration of the trust. And if you are an heir of a decedent, if you're a child, then you are entitled to notice. Even if you were disinherited, you are entitled to notice so that you can potentially contest the way it was done. Was there any undue influence? Was there shenanigans being performed when the decedent drafted their trust or signed their trust or made amendments, right? Many times the decedent makes amendments close to death, and perhaps there's some undue influence there. So you want to be very specific. You want to make sure that the beneficiaries are notified, and they have 120 days basically, if notice is properly done, to contest any of the terms of the trust. And once that time period passes, then they cannot bring a cause of action, which relieves the trustee of any fiduciary liability. Many times at the death of the first, there are no distributions being made because it's all for the support of the surviving spouse.